Welcome to Anchored in Law, an unembedded take on law. We're in conversation with Justice Madlanga of the Constitutional Court. Justice Madlanga, how would you say judges generally account? Are they accountable at all?
Yes, like any arm of state.
To whom are judges accountable?
We must not only be, but we are. We account to whom we serve, and whom we serve is the general populace.
Yeah.
That's who we account to, and that's who we must account to.
And how do judges account to the general populace?
Through our judgments. It's obligatory that you should give or hand out timeous and reasoned judgments. That's how you account. If failure to do so may cause the public not to have confidence in what we do. If we have reasoned judgments, by and large, that should, have an impact of causing right-thinking South Africans to have confidence in the judicial.
And so the manner of accounting by judges is not just judgment, as I understand it. It's a reasoned judgment.
A reasoned judgment.
So the general populace reading the judgment must be able to see how and for what reasons the judge or the court arrived at a particular outcome.
Yes. And right people differ on a variety of issues. They may disagree with you, but at least if there's an understanding of how you got there, it should still have the desired effect. And if I may add very quickly, now recently the Chief Justice has started the judiciary, started with the Judiciary Day. This year it was in its second year, where he will stand there and give a lengthy account of what the judiciary has done during the course of the past or the previous year. So that too is part of that.
Or the annual report.
Yes, the annual report, which is something quite new.
Yes, I attended the first one. I missed the second one. Now, I'm glad you raised the issue of a reasoned judgment, even though one may not agree with either the reasons or the outcome, but at least it is reasoned. I want to use it as an example the practice of both the Supreme Court of Appeal and the Constitutional Court. Of course, it's provided for in terms of the rules of both courts, of the both respective courts, where it comes to applications for leave to appeal. Now, not all applications for leave to appeal are heard in open court. Many of them, in fact, I understand, especially here in this court, are decided in chambers by the full complement of the judges to dismiss an application for leave to appeal, typically on the basis that there are no prospects of success or that it is not in the interest of justice to hear the matter. What puzzles me is that if judges account through reasoned judgments, isn't the litigant entitled to know the reason for a finding that an application for leave to appeal does not have good prospects of success, or that it is not in the interest of justice?
I'll answer the question at two levels. One being at soft, if I may call it, the soft philosophical or legal level. And it is that at the level of an apex court, which the Supreme Court of Appeal also used to be until quite recently, a litigant has had the benefit of reasoned judgments along the way. if it's a matter that emanated from the magistrate's court, the litigant will have gotten reasons from that level to the High Court, and then the Supreme Court of Appeal, and even more so at the Constitutional Court. So when an order simply comes out and says no prospects, the litigant must assume that it's on the basis that, well, reasons were given before I lost, so there are no prospects that something else may be said by this Court of Appeal. Then at a practical level, in your intro, you did say that the vast majority of applications are those that we dismiss in chambers. If I were, I've not done the sums, but if I were to venture, some sums, I would say what you see in court, the matters that we actually do sit down and have oral hearings in, and therefore give the reasoned judgments that you are talking about, in percentage terms, I would be quite surprised if that's not, about 10%, or I think even that is exaggerated. It could even be only 5% of what we handle.
So I should have said the vast majority of cases don't even make it to open hearing.
So just imagine if in all of those then we were to have to write reasoned judgments, if we would be able to cope, we would simply be swamped.
Yes.
And it becomes worse with this court because we operate in bank.
Yes.
All of us have to be part of each and every decision this court makes. It would just be totally
right.
impossible. But of course, for the one individual litigant, that's not much of a reason.
Yes.
Yeah.
Two things arising from your answer, Justice Madlanga. The first relating to the soft philosophical answer that a litigant must then assume that the prospects are not good because of what the immediately lower court has said. But isn't the litigant entitled to the reasons of the apex court, not the apex court adopting the reasons of the lower court? That's one thing. Secondly, at a practical level, isn't what you've just described, that the Constitutional Court sits on bank and they all have to decide a leave to appeal case as a collective, as a whole, isn't, and therefore practically it's not possible to hear every case that comes before the Constitutional Court. Isn't that an argument in favor of sitting in panels? I know the Constitution doesn't allow it, but isn't that a possible argument for saying, look, we can churn out more judgments if we set as, say, panels of 5, and then you increase the number of judges here from 11 to 15, and then you can sit in a day, you can actually hear full argument on at least 3 cases at the same time.
Let me just correct something. I think part of your latter question suggests that we may even not hear a matter purely because of the practical considerations I referred to. No, that's not the case.
Okay.
We have never not set down a deserving matter because of the practical considerations I referred to. Never.
No, I mean, that's not what I'm suggesting. I'm just...
Maybe I misunderstood.
Yeah.
I misunderstood.
No, I was dealing with the 2 levels at which you were...
Yeah, okay.
Yeah.
Anyway, let me just emphasize it, even if it was not your point. A deserving case always gets set down. So nobody will ever be disadvantaged because of the practical considerations I referred to. Those practical considerations relate only to giving reasons. And so that has nothing to do with, what we set down and hear. But with regard to giving of reasoned judgments, even when we dismiss, I assume dismiss without setting down. Maybe my answer on that will also touch on your earlier question. I would say the litigant has had his or her bite several times and has received a fair trial in terms of Section 34 of the Constitution. And at all these hierarchical stages, reasons have been given. At some point, I think it should be enough for a litigant to accept that even if the court has not said more than that there are no prospects of success, what it means is that what was said by the lower court is enough. So at a certain level, I think that should be accepted, especially with regard to an apex court.
Except the litigant doesn't have the benefit of the opinion of the apex court. Why can't they...
Implicit in saying there are no prospects, the opinion of the apex court is that what the lower court said
was correct.
Cannot be faulted.
Why doesn't it say so?
I as an individual, that's effectively what we are saying in saying there are no prospects. Effectively, in practical terms, that's what we are saying.
But Justice Madlanga, you said a litigant must assume. A litigant should never have to assume anything.
Let me tell you why. I actually used assume advisedly. And when you came in now, I wanted to actually explain myself. What I wanted to explain, or even, why I use assume is, I as an individual out of the 11 may perhaps be having slightly different reasons to another colleague, and another one may also be having slightly different reasons. But all of us may be having no basis whatsoever for faulting the outcome that was reached by the lower court. All of us accept the outcome. So in the end, we are saying there is no basis for saying that the lower court was wrong.
Okay, well, it's a debate on its own to be had, perhaps on another occasion, perhaps in a symposium setup. Judicial accountability, you said earlier, is about judges giving or rendering reasoned judgments. And one would expect that from that judgment must be an outcome. Now, in instances where, as has happened on at least 2 occasions, there may be more, in this court, the Constitutional Court, where there is a hung bench, where 5 judges, it's a bench of 10 judges, 5 judges would grant leave to appeal, and the other 5 would refuse it. The effect being that the judgment of the lower court then stands. Isn't that failure of accountability by the apex court?
I would not say of accountability. I would say more, let's take the Jacobs case, Shane Jacobs case, where the applicants had been sentenced to, I think, periods of imprisonment ranging from 15, 18. I'm not sure if there was something more than that, imprisonment. Somebody like that who comes to us, the outcome they are looking for is one that will take them out of prison, if you see what I mean. Especially one where they are appealing against conviction, not against sentence. Now, we were split, was it 5-5 or 4? I'm not sure.
5-5.
5-5, yes. The effect of that was Mr. Shane Jacobs and the others remain in jail for 15, 18 years. From where they are sitting, that is unjust. Justice has not been served from where they are sitting. And I think as a justice of the Constitutional Court, I should be prepared to own up and say we did not, what we did not result in justice being served. I think I just must immediately own up to that. I don't know whether I should say this, but maybe I should. Quite early on, after my appointment to this court, I raised with my colleagues, and at that time it had not actually arisen, I raised with my colleagues the question of the advisability of sitting even numbers. I did that well aware of what the Constitution itself says, which is that the quorum of the court is 8, which yes, I sit on the constitutional bench, and therefore I should be expected, I've taken an oath to uphold the Constitution. I should be expected to accept what the Constitution says, but I don't find that quorum provision to be a wise provision. And when I inquired about why we have that, I was told that the framers of our Constitution felt that a quorum of 9 was too high, a quorum of 7 was too low, and that 8 at least sounds more respectable. Well, but point is, even if that is what our quorum provision says, if we are more than 8, maybe, just as our own practical way of dealing with matters, we might ourselves have to do something about it. But to address the problem on an ad hoc basis like that, I don't think would be the right thing to do. I think something has to be done, whether it's by way of an amendment to the Constitution itself or some statutory amendment, which of course, for as long as the quorum provision stands in the Constitution, cannot tamper with that, So the best thing would perhaps be a constitutional amendment. I do not know. Recently, at conference, we agreed that we must do something about this. This was not after the Shane Jacobs matter. It was after another matter where, again, we were evenly split quite recently. It was a matter on intellectual property.
Yes.
We decided, no, we cannot go on like this. And it was agreed that 2 of the justices should look into the matter, see what happens in other jurisdictions, and to prepare a memo for other justices, and we then take it from there. So the concrete idea is that we do need to address this.
Yes.
It is simply not right.
Okay. Right, thank you for that. Now, judicial activism. What to you is judicial activism? Now, careful in your answer, because the next question will be, do you consider yourself a judicial activist? So, judicial activism.
For me, judicial activism should never go beyond recognizing what the law is, what the Constitution as the overarching law says, and upholding rights in accordance with that. And of course, insofar as it relates to me, that my approach, of course, will be informed by what I said is by judicial philosophy. But as I did temper that earlier, it is seeking justice within the confines of the Constitution, the law, not going beyond that, but not upfront putting curbs on what you can possibly do or what you can possibly achieve. You know, everything you do being informed by a rights-based approach.
Okay. Can you think of an example? I know this may be an unfair question. Can you think of an example where you personally have applied or worn or donned the judicial activist hat, whether as a magistrate or as a high court judge or as a constitutional court judge?
No, I'm not able to give an example.
You're not able to give an example.
All I would say is, you know, I'm just sitting as a judge. My makeup is as I have just described to you. It is that will instinctively and subconsciously inform what I do.
Well, let me give you an example, Justice Madlanga, and test your judicial activism. You would describe let's start there. You would describe yourself as a judicial activist, would you?
I'm not sure that I would. I don't.
Well, on the basis of the definition you've just given.
Perhaps I would. Perhaps it's best to leave it to others to pigeonhole me. And maybe let me not go beyond what I've just described, and what I have said informs my approach to matters I adjudicate or participate in. Then let rather it be others who then pigeonhole me.
Okay, we'll take this up in the next segment. Thank you, Justice Madlanga.
Thank you.